What's up, guys? Let's talk trial. Today is the 10th day of the Derek Chauvin trial. Yesterday was the 9th day, and they had a lot of substantive testimony that got put on yesterday by the prosecution and some cross-examination by the defense. And as the case develops, we are seeing certain problems or certain sub-themes that are popping up that are not beneficial for the prosecution. And as trial lawyers, as trial advocates, we got to keep an eye out for things like that. And when we see it happen in other cases, that's the best opportunity for us to learn from it, see why it happens, how it happens, and make sure it doesn't happen to us. So in this video, I'm going to break that down for you, what I consider to be two problematic sub-themes of the prosecution and how that could negatively impact the outcome of this case. Now, mind you, two things. Number one, I'm not saying they're going to lose this case. There's a lot of trial to be had, and the evidence that they have is pretty good for the most part. And number two, like every other video I've been making about this trial, this is not about judging other trial lawyers' work and whether that work was good or bad. That's not what these videos are about. These videos are about how we can learn from other trial lawyers, what they've been doing good, what they've been doing not so good. And so that when we do our trials, we make note of that and make sure that we're always improving, always going to the next level. So anyway, the first thing that's a sub-theme that's been developing that's going to be problematic is they have a shifting theory of prosecution, it seems. So when the opening statement started or took place, when the trial started rather, the prosecution's theory, the prosecution's story, for lack of a better word, even though it wasn't really any storytelling done during that opening, was that the cop had put his knee on Floyd's neck and that was a blood choke. It cut the circulation of his brain and George died, right? That was the theory then. And then they put on pretty much the first substantive witness, which would have been Mr. Williams, who's like the mixed martial artist guy who's fought professionally, an amateur and all that kind of stuff. And he's saying it's a blood choke, right? And he's sure it's a blood choke, and he told the cop it's a blood choke, and the cop acknowledged it was a blood choke, and he did it anyway, and he killed him. A couple of problems that I pointed out in my other video on this. Number one, it's clear that George was saying, I can't breathe, and with the blood choke, you can breathe. Your brain is just not getting the oxygen, so you're going to pass out. Number two, with the blood choke, you would pass out real quick if the choke is done right. You wouldn't be passing out for 9 minutes and 24 seconds. And so those problems were clear from the testimony initially, which is a problem for the prosecution if that's your theory. But even more problematic than that is that now that theory has evolved from a blood choke, which really does not interfere with your ability of getting air to your lungs, to now with Dr. Chauvin, who testified yesterday, he's saying it's basically an air choke. I mean, he didn't say those words, but what he's saying is that because of the pressure that was put on George by the cop putting his knee on his back or sitting on him or whatever the case was, that the ability of George to intake air was diminished to the extent that that killed him, meaning he couldn't breathe, is what Dr. Chauvin is saying. Now, there's a problem here because you're presenting two different theories of prosecution, two versions of what happened. And in the real world, it could only have gone one of three ways. One, it was a blood choke and not an air choke, and that's what killed George. B, it was an air choke and not a blood choke, and that's what killed George. Or C, it was a combination of both. Now, you may be thinking, well, it sounds like they're saying it was a combination of both, and that's kind of where the problem arises. If you're gonna advocate, if you're gonna try your case on it was a combination of both, then that's got to be the message from the beginning. It's got to be a uniform message that it was in fact the combination of both things that killed him. It can't be, oh, you're gonna hear about this blood choke, and then 9 days deep into the trial, you have a guy who's a doctor saying that it wasn't a blood choke, that it was an air choke, or whatever the case may be. So that's a big problem. Problem number two is the fact that there's this sub-theme developing that they can't find qualified experts to testify that are living in Minneapolis or Minnesota. The use of force expert was some California guy. Dr. Chauvin is some Scottish guy from, I forget, from Chicago or something. And so it's like every expert has to come from out of the jurisdiction, which is a problem in most cases, but it's even more of a problem in this case because the one guy who has some very, very bad facts for the prosecution is actually the medical examiner that is the medical examiner for Minneapolis. So you're going to have the one local guy who's an expert, who's qualified to testify, and that guy is going to be devastating to the prosecution's case. So it's almost like we're having all these outsiders come in and tell us what happened, and the guy who's the local guy, he's going to tell us something completely different happened. So that's a bad, bad situation. And the third sub-theme that's developing that I hope I'm completely wrong about, because this is the kind of stuff that loses cases. It seems that the prosecution's angle on this is they will not present the bad facts. They will not address the things that are devastating to their case. And I don't know what the angle is. I don't know if they're waiting for the defense to bring it out. I don't know if they're hoping that the defense won't bring it out. But I got the feeling that they will not put on their own medical examiner, the person whose job is to go ahead and find cause and manner of death from homicides, suicides, and anything really that happens in Minneapolis. The person that works really for the prosecution and the police departments there. And so if they don't put that guy on, because it's going to say some bad things for the prosecution's case, and the first time the jury hears about it is on the defense's case, and if the defense knows what he's doing, which he sounds like he's got a pretty good idea as to what's going on, then he's going to be the first witness for the defense and perhaps the only witness for the defense, or maybe they'll put a use of force guy or something like that. But I can almost guarantee if the prosecution's not putting that guy on, the defense is going to put him on first. And if the defense puts him on first, I'd say this case goes from a pretty winnable case to a toss-up, if not a loss for the prosecution. I hope I'm wrong about the fact that they don't intend to put that guy on. I hope I am absolutely 100% wrong. Unfortunately, it wouldn't be the first time something like that happens. Unfortunately, I've made like 3 or 4 different videos on lawyers trying cases, hiding the bad facts, just hoping and praying that they're not going to come out and the jury's not going to hear about it. And it just happens over and over and over again. And the opening statement in this case was a good indication that it's happening in this case as well. And so, I don't know, but there's a few things that are going on in the case that are going to be problematic for the prosecution from an advocacy perspective. Now you may be thinking, well, what are they supposed to do if the medical examiner is not supporting their case? Why would they put him on? Well, the jury's going to hear it anyway. So if what you're worried about is that the jury's going to hear bad facts for the case, then you shouldn't worry about that, because I promise you that guy's going to testify. The question is he going to testify when you call him, or is he going to testify when the other guy calls him? And in that world, I prefer to be the guy who calls him, because number one, I can tell the jury, look, these are the facts, right? Like, this is what we're proving, and this is what this guy is saying, and this is why what this guy is saying is not consistent with what actually happened, right? And you don't have to worry about the jury thinking that you lied to him, that you try to hide the evidence or anything like that. Number two, you put him on, you have a pretty controlled environment under which you can present the bad facts to the jury. So you will be directing the guy. And so in your direct examination, you're the one asking the questions about the things you want to bring out. And you can bring them out in whatever order and whatever light you want to bring them out. That's a lot better than having a defense be the one bringing it out for the first time ever and having the jury hear it how the defense wants the jury to hear it. So that's significant. And I hope I'm wrong, and the reason why I'm concerned about it from an advocacy perspective is because nowhere in the opening statement did the prosecution say, look, you're going to hear our medical examiner fuck this up, he's wrong about it, and this is why he's wrong about it. He didn't even mention the medical examiner from what I remember. And so I hope that's not the strategy. If that's the strategy, it's going to get complicated for them. So anyway, guys, that's it for now. I will catch you again next time.